Good morning, friends. Welcome to Legal Matters by Sai Babu Sankara. Today, in the law of torts, particularly in the chapter of negligence, we are going to discuss the remoteness of damage. So, there are two aspects, remote and proximate. If the damage is expected to be proximate, then the defendant is liable. If the damage is too remote, very distant, which we cannot expect, but the damage happens. So in such a case, the defendant will be held not liable. This is otherwise called test of reasonable foresight. So remoteness for damage will be decided on the test of reasonable foresight. If I give you an example, whether it is proximate or remote, it will be easy for you. Suppose a motorcyclist going at high speed, he hits a pedestrian who was carrying a bag, but in that bag there were bombs. So the pedestrian was hit, and due to the hit, the bombs, they struck the earth. There was chemical reaction, and ultimately the bombs exploded, due to which so many others, 20 persons were injured, and 4 persons, including this so-called person carrying the pedestrian, 4 persons died. So simply 4 persons died and 20 others injured. And the neighboring vicinity building, it was also almost collapsed because of the pressure. Now, this is the damage. Now, on whom you are going to fix up the damage? Is it proximate or is it remote? 100% proximate, because see, even though he has not got the intention of attacking the person carrying the box, he has hit him, due to which this is only the immediate reaction or immediate damage. So since there is immediate damage, definitely the motorcyclist will be held liable to pay compensation. If it is remote, so if you cannot expect, if it is so the effect is very remote, then he will not be held liable. Right? This is so how to draw line between the proximate and remoteness of damage. Please remember, first of all, the judge has to decide whether the damage is remote or proximate. If remote, defendant is not liable. If they are proximate, very close, and not too remote, then definitely the defendant will be held liable for the consequences, right? So there may be various causes for this, because here the building which he did not expect to collapse. So we have to check up whether the accident was a natural or probable consequence of the wrongful act of the defendant. Right? There are two important case laws. One is that is Scott versus Shepherd, 1892. Sorry, it's 1892. Right. So this man, the shepherd, he has thrown a lighted squid, that is togarantan or a tail squid, night time వేస్తుంటారు. So he lighted a damp squid into the crowd. So B, in order to avoid the same to cause personal injury, he has picked it and threw it on other person. He picked it and threw it on other person. Ultimately, it fell upon D, and it caused injury to his left eye, and his left eye has to be removed. So definitely the first person who threw the so-called kagada, yes, he was held liable because it is too proximate, it's not remote. Right. Second point, Emerson, Haynes versus Harwood, 1935. What happened is, Mr. Harwood is having a double bullock, it's not a double, horse-driven cart. So he went into the streets. He has got a servant. He kept it at some place. He went for shopping. The defendant servant, actually, he has released the horses. He tied them also from the cart. He released them, and actually he was taking rest somewhere. In the meanwhile, the children happened to see the horses. So children, they act smart. They started pelting stones on the horse. So one of the horses, somehow it managed to untether from the from the cart, and it started running. Actually, it's galloping. So at that particular time, a woman and a pregnant woman and her daughter, they were crossing the road, and definitely they will be actually attacked by this horse, because horses, they cannot see. Immediately, the traffic constable on duty, he has come to the rescue of these people, and he has thrown them, he helped them. At the same time, this horse caused injuries to him. So he was injured. Now, against whom they has to file the case? Of course, they filed the case against the defendant, that is owner of the so-called the horse-driven cart, right? Because of the negligence exhibited by his service, that is basing on the vicarious liability. But the defense was the mischief of the children. It was the approximate cause. Because the children hit it or pelted stones on it, it has reacted. Right? Is it not? That is the defense. But the negligence of the defendant service is the remote cause. Definitely, it is the remote cause. So, defendant servant cannot be held liable. Just now I told you. But still, the court held that the defendant is liable as, of course, the police suffered damage occasioned by a combination of wrongful act of the defendant servant and also further mischief by the students or children. So here, of course, they have also gone to another step. So the defense of novus actus intervenes, that is intervention of the third party, that the intervention of the third party is child. So they did not accept. Anyway, it's a negative example, but they have discussed at length about the approximate and remote causes. Now we are going to discuss the most important two case laws. One is Repolymeous Principle, Repolymeous and Furness, Wilby and Co. 1921. In this case, actually the test of reasonable foresight was well explained. Right here, Repolymeous, these people, they have engaged or they have chartered or they have taken on lease a ship to carry their cargo from some place to some place. Right? So actually this ship contained liquid benzene. So actually due to the movement, the liquid benzene spilled over, and actually it was held in the dock or hold of the ship. It was there. Of course, due to the negligent act of one of the servants, a wooden plank, it was of course somehow he has removed, he has thrown it aside, and that wooden plank fell on the benzene, which caused the friction and it started firing. Entire ship was burnt. So due to the negligence of course it's a remote, but still the court held that the Privy Council, the owners of the ship can recover the amount from the contractor for the damage, because they have hired Repolymeous, he has to pay the entire cost of the ship. In crores it would have gone. So why? Because although it cannot be foreseen by the defendant servant, but the damage is approximate, because since he has negligently thrown the so-called wooden plank on the liquid benzene, and it has caught fire. Therefore, you have to pay compensation. So here, damages are more important. But this principle was held up to 50 years. In the 1961, another case of Wagon Mound case has come. Till such time, it was actually in practice. Now the other case, Wagon Mound, this is called as overseas tank ship. That it belongs to United Kingdom. Overseas tank ship within brackets UK Limited versus Morts Dock and Engineering Co. Limited 1961. Right here, the appellant, that is overseas tank ship, they have chartered or they have taken on lease a ship called as Wagon Mound. Right? So it was kept in the Sydney Harbour. So the people are flowing, it was being, the fuel is being loaded into the so-called ship. Right? So while while this, definitely there will be some leakages. So the petrol was leaked and it has fallen into the sea. Is it not? That's the main problem. So there is a wharf belonging to Mott's Dock and Engineering Company. You may know wharf. Wharf is a place where the ships will be there and some repair operations are being conducted, or it is just like the platform or parking place from some ships. So it is located at a distance of 180 meters from the ship. There were some welding operations going on because they are repairing some ship there itself. So the petrol which fell into the sea, it has actually a large quantity has gathered into a large quantity, and it has swept slowly to the engineering, that is Mott's Dock. It has gone there because the sea will always be moving, is it not? So owing to the negligence of the ship's servants, what happened? The large quantity of oil, they are so careless. So this oil was spilt, it has been collected, and it has gone to the other side. What are they? There some welding operations are being carried on. So they are also a bit negligent. During the welding, some spark went out and it has fallen into the sea where the petrol was there. Immediately it was engulfed, right? So entire lot of damage. The wharf of the defendant, Mott's Dock and Engineering, and the equipment, they were totally destroyed due to the fire accident, right? So normally the Supreme Court, as per the Repolymeous Principle, since it was 180 meters distance only, approximate, then they have to pay damages like that. It held. But the Privy Council held that Repolymeous is not good at law. So they have changed the principle because the overseas tank ship, they did not expect that the petrol will be leaked, this petrol will go there and cause the damage. 180 meters is not ordinary distance. They have not, just like that Scott versus Shepherd, they have not thrown the lighted thing. So it has collected, it has gone, and slowly it has caused the accident. So it is definitely a remote test of reasonable foresight said that it is remote chance. Therefore, the defendants are not held liable. So a man must be liable for the consequences of his own act, not for the probable consequences of other act when they are remote. So these are very good cases. Please study them and enrich in your legal knowledge. Thank you very much.